I had a feeling this would be good, but it far exceeded my expectations. Hello again, my fam. It is Perez, the queen of all media, the original influencer, reporter, podcaster, your bestie, and the number one source for everything It Ends With Us saga. As I previously shared with you all, the actress formerly liked by some, formerly liked by Taylor Swift, went complaining to her bestie Judge Lyman recently. Butterdine Lively told the court that the Baldoni Wayfarer parties were deficient in their productions that were required to be handed over per the subpoenas that Subpoena Serena issued against them. So the wench of multitudes went to her lapdog and said, "I'm filing a motion to compel." Deja vu. It was very long. It had a fancy name too. Omnibus. 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 If you don't know what that means, omnibus refers to something that covers or includes many things at once. Translation, their mega motion to compel. And now, minutes ago, the Baldoni Wayfarer parties have responded, and it is savage. Gucci, ratchet. Wait, what is it? Fudge, I can't remember the lyrics now. Ratchet. Bougie, whatever, you know what I mean. It's savage. They object with a twist and spilling some tea, letting us know the real. Because, ethically challenged Ezra and her cohorts lie and misrepresent. You cannot trust the lawyers for Team Ridicula. And there is no foreplay here. The Wayfarer party's opposition to Blake Lively's omnibus motion to compel gets right to it. They say Blake Lively's motion to compel seeks to remedy alleged deficiencies in the Wayfarer party's document production. There is a footnote. It says, Lively's notice states that she moves to compel the Wayfarer parties to provide full and complete responses and produce documents in response to Miss Lively's discovery requests. But her omnibus brief only discusses the alleged deficiencies in the Wayfarer defendants' document productions. The brief does not seek any amendment to the discovery responses, and accordingly, that is not addressed in this opposition. Meaning, if you didn't catch something, if you didn't point it out in this big old motion to compel, sucks for you. The Baldoni Wayfarer parties continue saying, quote, Lively claims that there are gaps in the production, but fails to identify specific requests which the Wayfarer parties failed to fully comply with as required by Local Rule 37.1. I don't know. I remember her team giving specifics. Listen, I'm Team the Truth. I do remember there were a lot of specifics that they pointed out. It continues, nor does Lively certify that she met and conferred in good faith on all of the issues raised in her motion, because she did not. Despite these procedural infirmities, the Wayfarer parties agree to reconduct their review and supplement their production, mooting most of the issues raised in the motion. Well, that's easy. Unfortunately, this agreement could not be reached before Lively filed her motion, as it was brought only 4 business days after receipt of Lively's meet and confer letters. The Wayfarer parties' agreement to reconduct their searches to locate specific items Lively identifies does not, of course, admit the existence of responsive documents. This is so hilarious. I'm living for this real-life soap opera. Lively's speculation that there should be documents when there are none, or that there should be more documents than there are, is not a valid ground for a motion to compel. The motion to compel should be denied with respect to the remaining three issues. First, Lively asks the court to compel the Wayfarer. Oh, this will be really interesting to see what they really have issues with. They are, first, Lively asks the court to compel the Wayfarer parties to produce the search terms they used for the document review. They're objecting to that? The parties were required to meet and confer and agree upon search terms in May 2025 pursuant to the Protocol for Discovery of Electronically Stored Information and Hard Copy Documents. Lively declined to do so at the time and now asks that the obligation to make the exchange be imposed only upon the Wayfarer parties. While the Wayfarer parties are willing to engage in a mutual exchange, Lively insists it should be only the Wayfarer parties' obligation. The motion should be denied as to this issue. Okay, that makes sense. Whatever she is asking of them, she should provide as well, is what I take from that, right? And if at any point you disagree with my assessment of this opposition, please chime in the comments section, all right? Because I am getting my Elle Woods on now, but I am not a lawyer. Second, they continue, Lively asks the court to compel the Wayfarer parties to produce all documents responsive to their requests for production, approximately 100 directed to each defendant through the present day. Again, the ESI order requires the parties to meet and confer and agree on date ranges before reviewing and producing documents. Lively declined to do so. Well, no wonder their productions were deficient. Her obligations were deficient too. And that's on you. We know she doesn't stand on business. Instead, Team Wayfarer tells the court, both parties proceeded to produce what they thought was reasonable, limiting their productions to documents dated at the commencement of litigation. Lively contends that the Wayfarer parties must search for and produce documents through the present because she alleges an ongoing smear campaign. The phrase smear campaign is not defined, but appears to refer to a series of allegedly defamatory statements. If that is the case, then Lively should have, but did not identify which specific requests warrant extending the date range beyond the commencement of litigation, as many of the requests do not address this subject. The motion must be denied as to this issue. We know how Judge Lyman is going to rule. Even though this sounds sensible to me, the corrupt judge is in her pocket. He is bought and paid for. He is biased. Third, Lively seeks to compel two categories of documents that are the subject of her pending requests for production, answers to which are not due yet. The motion is premature as to these requests. The first category of documents that are not yet due is Lively's request, meaning so they don't have to hand them over yet, Lively's request for all communications on the platform Signal. This is the subject of Lively's most recent requests for production, responses to which are due on August the 15th. So why'd she ask for a motion to compel if they don't even have to respond by August the 15th? Such a waste of the courts, such a ridiculous... Lively also seeks to compel Brian Friedman's communications with press and social media content creators. The court recently directed Lively to propound this request on the Wayfarer parties. Lively has not done so. Thus, the motion is premature on this issue, and the motion must be denied as to this issue. Once again, sensible. So it will likely not go their way. Sorry. They then go into pages and pages of background, which is basically just a declaration. This happened, then that happened, then this happened, then on this date, and then on that date. It's long. We don't need to go through it all. I just wanted us all to know the meat and potatoes and the reasoning. So, argument. The Wayfarer parties agree to supplement their productions, mooting the majority of issues raised in Lively's motion. The Wayfarer parties agree to supplement their document production on a rolling basis to be completed by August 22nd. That's fairly soon, which moots most of the issues raised by Lively's motion. First, as requested in the motion, the Wayfarer parties will reconduct their search for and produce any additional non-privileged documents in their possession, custody, or control as identified in the motion, including the following categories. We don't need to go into it all. By agreeing to reconduct their prior searches to locate allegedly missing documents, the Wayfarer parties are not agreeing that additional documents in fact exist. To the extent that Lively suggests that there should be documents responsive to her requests where she found none or only some, her speculation cannot warrant her motion to compel. For instance, Lively claims that there should be documents concerning the use of social media bots, trolls, troll farms, paid or incentivized accounts, or seeding, amplifying, boosting, or planting content. The Wayfarer parties did not engage in these activities, and therefore there are no documents responsive to these requests. Oh my God. This is one of the key focal points of the alleged smear campaign. Planting content. In no uncertain terms, Baldoni and the Wayfarer crew have just told the judge they did not plant any content. How do you settle this? How does the judge, the crooked, corrupt judge, prove that Team Baldoni Wayfarer is telling the truth here? That is a fascinating conundrum. Their opposition continues. All Lively has is speculation that this conduct occurred, which is insufficient to warrant a motion to compel. As another example, Lively insists that it is suspicious that the tag defendants, Melissa Nathan and company, have produced only minimal documents concerning harassment, discrimination, retaliation, or other workplace misconduct on set. Lively's speculation that more documents should exist is nothing other than speculation and is not a basis for a motion to compel. While the Wayfarer parties are willing to conduct additional searches for particular documents identified in the motion, that does not mean that additional documents in fact exist. Also, the Wayfarer parties reveal that they've gone over some privilege logs, and some are not protected by attorney-client privilege, and they will hand that over. Plus, the Wayfarer parties will modify redactions, which they had a lot of issue with. Their opposition continues, arguing, Lively is not entitled to the Wayfarer search terms after declining to mutually exchange search terms in May, as required by court order. Also, the Wayfarer parties should not be compelled to produce documents responsive to all of Lively's voluminous requests through the present. Oh, snap! They argue that both Lively and Wayfarer requested production documents through the present. Both parties objected that the time period was overbroad, sought material that was not relevant nor likely to lead to the discovery of admissible evidence, and requested information was not proportional to the needs of the case. Lively only produced documents through December 31st, 2024. Even though she stopped sharing info at the end of 2024, no documents or anything from 2025, she wants that from them. They requested that of her, and she's not giving it up. They continue, saying, days before the deadline to move to compel, Lively raised for the first time her contention that the Wayfarer party's production was deficient because it did not contain documents responsive to her numerous requests through the present date. But they tell the judge the date limitation used by both parties was apparent by at least July 1st, 2025, when the document productions were substantially complete. That's well over a month before she filed this omnibus. Meaning, they should have raised these concerns more than just days before the deadline to move to compel. Wayfarer continues, she argues because she alleges an ongoing smear campaign, all documents, regardless of the subject matter, must be produced. But Lively's numerous document requests are not limited to the alleged smear campaign, nor is her complaint. And they're now calling her a liar. Well, her legal team, because they are, in my opinion. Contrary to Lively's suggestion, the court did not previously reject a December 20th, 2024 cutoff date for all discovery. Rather, the court rejected that cutoff date for the purpose of specific targeted interrogatories. At issue were Lively's interrogatories to the Wayfarer parties seeking their communications with reporters and news and media outlets concerning Lively Reynolds, this action, Lively CRD complaints, and the Lively companies. We get it. Nor did the court rule that all documents from all parties through the present must be produced. Is it normal for lawyers to lie or misrepresent this much in court filings? Bonkers. And they say, if the court requires production of documents after the commencement of litigation, a production through the present would be too burdensome. Oh, now they're sharing why it's just not feasible. A more reasonable cutoff date would be the date of the filing of Lively's amended complaint on February 18th, 2025, as her allegations of defamatory statements made about her, the smear campaign, are only alleged through the date of the complaint. Well, she did just file a second amended complaint, so look at me. Look at me. I like to be real, always, and honest. Not February, just a couple of weeks ago, she filed another amended complaint. with new information and new allegations and new smearing. Further, any extension of the cutoff date for discovery relating to the smear campaign should also apply to Lively. True. Lively alleges in paragraphs 296 through 299 of her complaint that she was harmed by statements made by the Wayfarer parties and their counsel. The Wayfarer parties claim that Lively's own statements to the press, her own public behavior, and the statements of her attorneys caused the harm she alleges. Translation, you're making all these accusations, but babe, here's a mirror. Look into it. For example, Lively may be in possession of social media communications and analysis from after the date of her filing indicating that the backlash against her is a response to her public conduct and that of her attorneys. Furthermore, if Lively seeks to recover damages from events she claims are ongoing, she must produce evidence relating to the amount and causation of those damages. Therefore, any order extending the cutoff must impose a mutual obligation. And remember what I told you just a little bit ago? She only produced her crap through the end of last December 2024. You are deficient. Finally, to the extent that the court requires the Wayfarer parties to produce documents post-commencement of litigation, this is going to be the key thing for the judge to decide. Should the court require the Wayfarer parties to produce documents post-commencement of litigation in response to requests regarding the smear campaign, it should reject Lively's demand for a privilege log of documents after the filing of the complaint. As one of the cases Lively relies upon makes clear, even if documents dated post-complaint are relevant, that party need not individually identify each privileged communication created in connection with the litigation, given that once litigation begins, most communications are privileged. That makes sense. And if they want his lawyers to summarize every single communication, God, do you know how much money this all would take? Do you know how many untold millions that would cost? Bonkers. All of this is, there is no soap opera better because this is just next level crazy and it's real. They also add, the motion seeking to compel signal chats is premature as the subject of Lively's fifth set of requests for production due August 15th. Plus, the motion seeking to compel Liner's communication with the press and social media is premature. Lively seeks to compel the Wayfarer party's agents' communications with third parties, including content creators, social media, and public relation firms. But the motion seeks only communications between Liner and specifically Brian Friedman and the press and content creators. Can they file another omnibus now? Or is it this was your one shot? Good question. If anybody knows the answer, share it in the comments section. So, for the reasons set forth above, the motion should be denied. The judge is going to have a very busy week. Weeks plural. August is where everything is coming to a head. Including me. All right, my fam. I think history will repeat itself again, as I already shared. She will probably get almost everything she wants, I think. But they should get everything too. There is too much sense in this. Judge Lyman does not like sense. He's biased. Anyways, I've said that enough. All right. Thoughts? Let's discuss everything in the comment section.